will give a speech about.
Não, professor Blanco de Moraes será o professor Miguel Raimundo é o moderador.
Muito bem. Então, esperamos pelo professor Miguel Raimundo.
Ele já está connosco. Estávamos a pensar começar às 3h05.
Já o estou a ver. Então começa às 3h05. Muito bem. Senhora.
Portanto, a ordem é a seguinte: o professor Miguel Raimundo faz a apresentação, depois a professora Ana Betina Kaiser faz a apresentação dela, depois a professora Ana Raquel Muniz faz o primeiro comentário e eu, por último, antes de abrirmos questões de fora.
Muito bem. Sim, senhora. Então, esperamos ainda mais alguns minutos.
Estamos no limite. Íamos começar, se calhar.
Talvez. Nós gravamos
Sim,
a intervenção, não é?
Sim.
Muito bem.
Posso abrir?
Com certeza.
Can I open the room? Okay. So I'm going to admit people. Okay.
O streaming está no ar também. It's on the air.
So, good afternoon to you all. I would like, on behalf of the Lisbon Center for Research in Public Law of the Law School of the University of Lisbon, to welcome all participants to this online event. I would like to extend a special thank you to our keynote speaker, Professor Ana Betina Kaiser, from the Humboldt Universität zu Berlin, and also to Professor Ana Raquel Muniz, who is joining us from the Law School of the University of Coimbra, giving us the honor of her presence, which will surely help us reflect on the conference that we will hear from Professor Ana Betina. I also greet Professor Miguel Nogueira de Brito, my colleague at the Law School and Research Center, which is also on this panel and will be making some comments. Let me also extend my warm welcome to Professor Carlos Blanco de Moraes, the head of the Lisbon Center for Research in Public Law. I would like to frame a little this initiative by saying that when a group of researchers here at the law school, of which Professor Nogueira de Brito and I are a part, joined up a few months ago to carry out a research project in the area of states of exception, in which we try to touch themes both of constitutional and administrative law, which to us, it is very clear that cannot be thought of separately in this context of the states of exception. We immediately thought of Professor Ana Betina Kaiser to give us a first lecture on this topic. We hoped it would be in person, but unfortunately the same pandemic, which has caused more and more interest on this theme, also limits these possibilities, so we're doing the conference online. Professor Ana Betina Kaiser is an associate professor at the Law School of Humboldt Universität zu Berlin, as I said before. As of May 2014, she has been teaching public law and foundations of the law at this law school. She also holds an LLM from Cambridge University. And in what concerns her academic track, in addition to an impressive series of studies and publications, mostly in the fields of constitutional law and theory of law, in 2017, she successfully presented her habilitation thesis at the Albert Ludwigs Universität Freiburg, titled Ausnahmeverfassungsrecht, that is, constitutional law or of emergency or exception, or simply emergency constitution. This extensive work was published in German in 2020 by Mort Siebeck. Obviously, even though it was thought of in Britain before the COVID pandemic, I think it, as we were discussing, it would have been difficult to find a more suitable reflection about what is clearly a classic theme of public law, with a recent illustration, which is probably the first with this kind of intensity and relevance in most of our lives' time. So these are truly times that are stressing the boundaries of the constitutions of the law, and this is exactly the topic that Professor Ana Betina will be talking to us about. we are faced, as she will undoubtedly tell you, with essentially two models, the suspension model, which she calls the suspension model, and the restriction model, as Professor will certainly elaborate on. She will give us a talk. The talk is titled "The State of Exception under German Law and the Current Pandemic, Comparative Models and Constitutional Rights." And it is therefore with great expectation that we will hear her and draw I'm sure, many ideas for this so decisive topic. So please, Professor, you have the floor.
Thank you so much for the kind invitation and introduction. Let me start by introducing to you the German legal framework applying in times of crises and in the current situation of the pandemic in particular. In a second step, I will present some current constitutional and administrative law issues that have arisen during the pandemic. The German Basic Law contains a number of provisions that apply to existential situations of crises. They may make up what I call, as Miguel has just mentioned, Germany's emergency constitution, Ausnahmeverfassungsrecht. In contrast to the constitution of the Weimar Republic and its now infamous Article 48, which handed broad powers to the president in states of emergency, the Basic Law does not contain a general provision covering all emergencies. When introducing the amendments of the state of emergency in 1968, the constitutional legislator instead opted for a model that regulated the various states of emergencies and their respective regimes with great specificity. Chiefly, the Basic Law provides for the classical emergencies, and that is internal emergency and war, where we have the difference between state of tension and state of defense, but one could say a war. And Article 35 adds provisions on natural catastrophes. Maybe let me add that when the Basic Law entered into force in 1949, those articles were missing or only in a very rudimentary stadium, and then the constitutional legislator amended the constitution and introduced that emergency constitution in '68. Most notably, the Basic Law rules out any suspension of constitutional rights during emergencies. Instead, it allows for the restriction of constitutional rights only. I call this model, as it was mentioned before by Miguel, the model of restriction. In contrast, the traditional model of the state of exception, the so-called state of siege of 19th century, always foresaw a suspension of constitutional rights. This model of suspension was invented in France in the 1840s and disseminated from there throughout Europe. It was adopted in Prussia too, and later was introduced into the aforementioned Article 48 of the Constitution of the Weimar Republic. But the Basic Law, Germany's current constitution, ended this tradition, whereas Portugal's constitution still knows the suspension model, if I'm not mistaken. And the French constitution too. What follows from this for the current COVID-19 pandemic? First, there is no health emergency in the constitution that could be relied upon in the current crisis in Germany. The existing categories, internal and external emergencies and natural catastrophes, do not fit our current situation. As there is no residual general provision, the current crisis has to be dealt with through the ordinary provisions of the Constitution. the extensive restrictions of constitutional rights that were introduced in Germany during the COVID-19 pandemic have to be tested against the catalogue of constitutional rights within Articles 1 to 19 of the Basic Law. As none of the provisions in the Constitution of Emergency apply to the COVID-19 pandemic, the central instrument for fighting the crisis is a statute, the Federal Protection Against Infections Act, which was amended in March 2020 and several times since then to accommodate to the current situation. What was particularly adapted was the Act's paragraph or section 5. Its new paragraph 1 introduced at the level of statutory law a new state of emergency into German law, the epidemic emergency of national concern, it is called, a term closely mirroring the WHO law. Also in March, the Bundestag declared such an epidemic emergency and has not yet lifted it. The most important legal consequence of its declaration lies in the fact that the Federal Ministry of Health is now allowed to issue executive rules in several areas. I will return to that. Even before these changes, paragraphs 28 and 32 of the Act delegated to the Länder, since we are a federal system, the power to issue executive rules to combat the pandemic. But please note, these two sections are old sections, so when they were enacted, nobody thought about nobody thought of COVID-19, right? So I don't know what the legislator had as an idea, but not such a serious pandemic, probably. Starting March 22, 2020, these regulations repeatedly, adapting them to the changing situation. The first measure those rules introduced was the so-called lockdown in March and April. This included soft curfews, social distancing rules, bans on social events and demonstrations, as well as shutting down businesses, schools, and daycares. The executive rules also served as the vehicle for the subsequent easing of these restrictions. We had an easing in the months of May. Shops and on public transport. In October 2020, a so-called lockdown light was ordered, closing in particular restaurants, clubs, cinemas, and theaters in all of the Länder. As of December 16, that meaning yesterday, the COVID regulations by the Länder provide for a hard lockdown, a strict lockdown, including the shutdown of all shops with the exception of grocery stores, and schools and child daycares are also closed. I do now come to some current constitutional and administrative law issues after having presented you the legal framework so far. The measures that have certainly demanded and still demand most of the general public are the massive restrictions on fundamental rights. They affected and still affect a considerable number of constitutional rights. This includes notably the right to move freely, restricted, for example, by quarantines, the right to free religious exercise, restricted by the temporary ban, as it was the case in March and April 2020, on all religious services as far as they involved meetings in person. The right to academic freedom, restricted by the ban on classroom instruction at universities. The freedom of movement, restricted, for instance, by the ban to travel to weekend homes. The right to a profession, affected by the shutting down of stores and restaurants. And not least, the right to assemble freely. This raises the question whether or not all of these restrictions are in line with the basic law. As mentioned, as it does not allow, the basic law does not allow the suspension of constitutional rights, it instead follows a one-size-fits-all model. That is, its constitutional rights protections apply both in normal times and times of emergency. At the same time, however, all rights protections contained in the basic law can what we call limits on limits, Schranken, Schranken. These include the so-called irremovable essence or the human dignity core of the respective rights. These protections are what I call the negative constitutional law on emergencies because they set final limits to the state's power to restrict constitutional rights, especially in times of crisis. The proportionality principle holds a central position in German constitutional law. It states that a constitutional right can only be restricted if the restriction pursues a legitimate aim, is suitable and necessary to further that aim, and is not, in its means, disproportionate to the aim pursued. It is hard to overestimate the importance of the proportionality principle in the practice of the German Constitutional Court. Against this backdrop, it comes as no surprise that during the pandemic, the at times very far-reaching restrictions gave rise to the question of their proportionality. For many, particularly for small businesses, the shutdown might mean bankruptcy, even though the state spends enormous sums of money in order to compensate businesses for their loss. And still, the question came up whether these measures were and still are proportionate. And indeed, the courts have been reviewing the proportionality of the COVID measures since March. In a few eye-catching decisions, they declared some of the measures disproportionate. Several higher administrative courts lifted, for instance, bans on accommodation for hotels. However, most cases in which the plaintiffs raised the issue of disproportionality remained unsuccessful. This is particularly true for the measures taken in March and April. For what reason? The main reason for the plaintiffs' lack of success is that the proportionality principle remains a weak standard in existential situations of crisis. When the good that the measures are meant to protect is of such overarching importance as hundreds of thousands of lives, most state measures will turn out to be proportionate. A second reason why the proportionality principle is difficult to operationalize in times of emergency is the lack of knowledge that usually comes with them. When reviewing the suitability and necessity of a measure, such as temporarily closing down a daycare center, courts do not have more information at their disposal than the executive issuing the rule. They both have to rely on the same sources at any given time, typically the scientific reviews and summaries published by the Federal Robert Koch Institute that it's can somehow called a knowledge structure of Germany. To stay with the example, which role children play in the transmission of the disease remains unclear to this day. As a consequence, all a court can do when reviewing the suitability necessity of a measure is refer to the regulator's prerogative. For this reason, other standards of control became important, such as the equality clause. That's Article 3 of the Basic Law. Let me give you an example. When the so-called Corona regulations by the Länder allowed for an easing of the restrictions after the first lockdown in March and April, some of those regulations allowed for the reopening of small stores and shops only. In contrast, big shops with a sales area of more than 180 square meters had to remain closed. Plaintiffs questioned this differentiation. A second example concerns the prohibition of prostitution during the lockdown. The plaintiffs again relied on the equality clause with the argument that there was no proper reason to prohibit prostitution, but to allow hairdressers, nail studios, etc. And the plaintiffs were successful. In the future, even the balancing free essence of constitutional rights, stating that the essence of a fundamental right must not be touched, may prove an important backstop that sets final limits to the state's measures. In the last decades, however, this rule did not have any meaning. Instead, it was understood as another instantiation of the principle of proportionality. However, since the principle of proportionality becomes a weaker standard in times of crisis, this principle could become essential. At least that was the proposal of my book Ausnahmeverfassungsrecht. But so far, the courts have not referred to this norm, probably because the rule did not play any role in the past, and maybe because the courts tend to support the measures taken to fight the pandemic. In what follows, I want to focus on the freedom of assembly, a right that was intensely restricted. Most COVID regulations the Länder issued in March 2020 contained explicit or implicit bans on all demonstrations, and only some included very limited exceptions to that ban. As a consequence, most authorities forbade any planned demonstration. The reason why these restrictions were so problematic was because they essentially lifted the right to assembly altogether during the time they were in force, which was mostly during the months of March and April. To compare, the bans on religious service, especially during the Easter holidays, also limited the right to free religious exercise to a remarkable degree, but still left some of the rights protections, such as the right to congregate at home, in place. The same cannot be said for the freedom of assembly during the first lockdown. Factually, the freedom of assembly was suspended by most of the COVID regulations, with the exception of the Land Bremen, which is something the Basic Law does not allow. As mentioned, the Basic Law forbids that a constitutional right is touched in its essence or core. But that was the case here. For these reasons, one should welcome that the Federal Constitutional Court, in an injunction, interpreted a COVID regulation from Hessen in a way that turned the tide on how the freedom of assembly was addressed in the courts. The Karlsruhe Court refused to read a blanket ban on all assemblies into the Hessen regulation. The city of Gießen, where the case had arisen, subsequently had to revisit the question whether an assembly of 30 participants could not take place. Indeed, it allowed the assembly to take place under very strict safety requirements. As a supplement, I would like to note that there were huge demonstrations, for example, 40,000 protesters in Berlin taking place in Germany in the summer in several big cities like Stuttgart, Berlin, or Munich. Here, the opposite problem arose. Protesters very often did not adhere to the standards of hygiene. For example, they refused to wear masks and to keep the necessary distance. Since the demonstrations were so huge, it was difficult for the state to enforce the necessary hygiene rules. Finally, many of these demonstrations had to be dissolved by the police. Allow me to make a small digression at this point. Now that I have presented to you the German model concerning the protection of constitutional rights during times of crisis, it might be interesting to ask, what are the advantages and the disadvantages of the German model of restriction in comparison to a suspension model? This question is all the more urgent since Portugal seems to combine both models. First, it seems a clear advantage of the mere restriction model that at least the essence of a constitutional right has always to remain untouched. De jure, this means that even in times of the pandemic, it has to be possible to demonstrate or to attend worship. Second, the fact that a suspension is not possible has also procedural consequences. Thus, you can always go to the Federal Constitutional Court, submit a constitutional complaint, eine Verfassungsbeschwerde, and thereby rely on your constitutional rights. Think of the example concerning the freedom of assembly that I have mentioned before. Here, indeed, a constitutional complaint was lodged and it was successful. In a suspension model, there wouldn't be any constitutional rights left that you could rely on. Third, the mere fact that the constitutional rights can never be suspended, not even in the most severe crisis, has also a psychological effect. Whatever happens, at least the core of your constitutional rights have to remain untouched. So far, the advantages. But what about the disadvantages? First, it came as a surprise for many citizens that constitutional rights under the Basic Law can be restricted in such a far-reaching manner. Many citizens, including many academics and my colleagues even, therefore experience the current measures against the pandemic as a de facto suspension. Second, the courts, as I have mentioned before, always rely on the principle of proportionality. They have much experience with this principle and it always worked. Now, one problem seems to be that at least the administrative courts do not want to acknowledge that this principle is rather weak in times of crisis, as I have mentioned before. However, when I presented this thesis on the weakness of the principle of proportionality on the German Juristentag, that's the meeting of the German jurists and lawyers, there was something like an outcry, how I could dare to say something against this principle. Somehow it developed as a holy principle, you know, in German law. But my proposal was and is that the courts should have changed to the crisis mode and should have applied the irremovable essence principle. Yeah, the core of the constitutional right shouldn't be touched. But since there exists merely no legal doctrine on this principle, the courts go on as they have always done. Third, politics is first and foremost oriented towards fighting the pandemic. They are less occupied by the question of protecting, for example, the right of assembly of those who don't want to see the danger of the pandemic or who might even adhere to conspiracy theory, and there seem to be many of them in Germany, and who therefore don't wear face masks during demonstrations. In sum, we can observe a certain adaptation of the two models, even though there remain important differences. I now move on and come to a more organizational point, leaving the realm of constitutional rights. The second highly contested question that I want to address is Section 5 of the Infection Protection Act, amended in March and again in November of this year. A central problem of the provision lies in the fact that once an epidemic emergency of national concern is declared, its paragraph 2 gives to the Federal Minister of Health the power to issue regulations that may even deviate from a number of federal statutes. While it is true that paragraph 2 was modified again in November, the provision remained unchanged in its core. Scholars of constitutional law have described this new Section 5 as, I'm citing, opening the constitutional floodgates. End of citation, end of quote. The reason for such a sensitive reaction is partly historic. In the Weimar Republic, the president's practice of issuing emergency regulations pursuant to Article 48 of the Weimar Constitution played a hugely important role. One consequence of this practice was that at the end of the Weimar Republic, the Reichstag had basically ceased to pass laws. The founding fathers and mothers of the Basic Law drew important lessons from this. For one, the Basic Law explicitly rules out emergency regulations. For another, its Article 80 limits the power to issue executive rules in important respects, specifically to protect the primacy of statutory law. A number of voices among constitutional law scholars were reminded by Section 5, paragraph 2 of the Infection Protection Act of the practice surrounding Article 48 of the Weimar Constitution. In the very first real state of emergency of the Federal Republic, the Bundestag was prepared, they felt, to abandon its legislative responsibility. The legislature, they claim, did not only leave important lawmaking functions to the Federal Minister of Health through that delegation, but also, and that touches the core of the problem, granted him the power to decree exceptions from statutory law. What exacerbated the problem under this view is that the statutes from which the minister may deviate are only listed in a very general manner. For instance, he may deviate from the Pharmaceutical Products Act, instead of very precisely naming specific provisions within these statutes. And lastly, the view considers it highly problematic that the Federal Minister of Health and not the Federal Cabinet could issue these regulations unilaterally. What should we make of these arguments? I want to plead for a modifying, sober line. Section 5 of the Infection Protection Act does indeed raise constitutional doubts. There are convincing reasons that the new provision is unconstitutional due to the manner in which it allows executive rules to deviate from statutory law. Such regulations may be constitutional in exceptional cases, but Section 5 seems to overstep these exceptional cases when it names the statutes from which the executive can deviate only very generally. And not least, the provision raises federalism issues. But notwithstanding the fact that the provision is unconstitutional, the accusation that it opens the floodgates overshoots the mark by far. It takes very careful constitutional analysis to assess whether the provision is unconstitutional or not. all the more so as the legislature included a sunset clause according to which the delegation loses its force on April 1st, 2021. The question whether the provision is unconstitutional is thus an ordinary question of constitutional law, one which will at some point be settled by the Federal Constitutional Court. Opening floodgates and is quite a different manner, and some of my colleagues even compared it to the manner the last Reichspräsident during the Weimar Republic acted. So I would say those comparisons really don't fit. Therefore, comparing the provision to Article 48 of the Weimar Constitution is absurd. As a side note, it should be mentioned that to the limited extent in which the Federal Minister of Health has made use of the delegation, the substance of his regulations was lauded even by the critics, though some called for transferring them into statutory law, and there they are right. In a final point, I want to address the constitutionality of prominent individual measures in the COVID regulations of the Länder. Both constitutional law scholars and the courts are debating, for example, the shutting down of businesses. The legal problem that these measures pose is the following. As mentioned, the Infection Protection Act, in its sections 32 and 28, delegates to the Länder the power to pass executive rules combating the pandemic. The Länder have used this delegation to take far-reaching measures. The problem is that Section 28 of the Infection Protection Act does not specifically describe the measures the Länder are allowed to take, and instead speaks very broadly of necessary protective measures. Established constitutional doctrine, however, requires that Parliament itself, as opposed to the executive lawmaker, settles those issues that raise fundamental constitutional rights concern. The so-called parliamentary prerogative, itself a consequence of the so-called Wesentlichkeitslehre, the essentially doctrine. This means that the legislature itself ought to decide whether it is possible to shut down businesses, raising the question whether the Länder executives were competent to take these measures instead. As a matter of fact, the courts did occasionally voice doubts whether those sections of the Infection Protection Act could be considered a sufficiently specific basis, especially for permanent, indiscriminate restrictions of the right to a profession. While the injunctions of the first months of the pandemic upheld the COVID measures, including soft curfews and shutting down businesses, this situation changed gradually. In autumn, the courts finally required explicitly a new legal basis by Parliament to specifically set out and describe the individual measures in the Infection Protection Act that most affect constitutional rights. In November 18, Parliament finally reacted and passed the new Section 28A Infection Protection Act that fulfills the conditions. So finally, this problem seems to be solved, but one has to ask why had this to happen so late? It was the Parliament really acted too late. Both the federal level and the Länder have fared comparatively well with the strategies they have pursued during the first lockdown in March and April. An assessment of the effect of the current reactions is not possible yet. The measures that were taken did, however, at times strain the limits of what is constitutionally permissible. And still, the rule of law is functioning as it should. The sheer number of over 1,000 published administrative and constitutional court decisions on pandemic measures attests to that. What remains open, however, are the economic consequences. Thank you so much for your attention.
Thank you so much, Professor Anna Bettina Kaiser. It was an absolutely outstanding lecture. Thank you for that. It was interesting to see that even with very different models between Germany and Portugal, I think that we identify with most of the problems that you mentioned, and this is, I think, very interesting for the debate to come. As you know, this conference will be commented on by the two professors from Portugal that I mentioned in the beginning. The first that we will have the pleasure of hearing is Professor Ana Raquel Gonçalves Muniz, and she's an assistant professor, as I mentioned, at the Law School of the University of Coimbra. She has her PhD, even though she has a very broad set of research interests, which range from administrative law to constitutional law. Her PhD is on the refusal to apply regulations by administrative authorities based on unlawfulness, a contribution to the theory of regulations, 2012. But she has a very interesting, far-reaching scope of publications with focusing on topics of administrative review of administrative decisions, the intensity, the control, which I think is a very relevant topic and which Professor Ana Bettina also mentioned in her talk. Recently, Professor Ana Muniz published a very interesting book on constitutional rights and their circumstances, crisis and bindingness of constitutional rights between state, society, and the global community. Thank you again, Professor Ana Raquel Muniz, for presenting your comments to Professor Ana Bettina's lecture. You have, as we discussed, roughly 20 minutes, even though after that it's possible that some debate arises between the lecturers. So Professor Ana Raquel Muniz, please, the floor is yours. We are happy to hear you.
Thank you, Professor Sir Raimundo. It is indeed a pleasure and an honor to meet you all in this seminar dedicated to the state of exception under German law and the current pandemic, comparative models and constitutional rights. I wanted to thank to Professor Miguel Nogueira de Brito for this kind invitation, as well as to Professor Blanco de Moraes, the president of the Centro de Investigação de Direito Público of the University of Lisbon Law Faculty. Naturally, I wish to salute Professor Ana Bettina Kaiser for the opportunity and for this clear, deep and significant speech. It is indeed an honor to meet you and to learn with you. And of course, I could not forget again to greet Professor Miguel Assis Raimundo and thank you for your so and very kind words. And I cannot imagine a more fitting panel than the grouping present today to discuss the assigned theme. And I'm really keen to learn with all of you, especially when we have the honor to discuss with Professor Ana Bettina Kaiser, renowned author of the recent book Ausnahmeverfassungsrecht, that is to say, Germany's emergency constitution or constitutional law of exception, if you say. As in Germany, Portugal is experienced this constitutional and I would say that this administrative law of exception. And we have to think that rule of law, Rechtsstaat, and état de droit, they are key concepts of our constitutionalism based on the protection of fundamental rights. And the main problem that the theories of the law of the exception must solve is the balance or the dialectics between the safeguard of fundamental rights and guarantees and the government's urgency to act. A quick overview on Professor Kaiser's speech demonstrates demonstrates that the constitutional law of normality is disabled in dealing with emergency and severe crises like pandemics. But the praxis and Portuguese experience too, they reveal that perhaps also the law of the exception is not skilled enough to take the consequences of a long-term crisis. For instance, the 7 traditional topics Professor Kaiser identifies as main theses in the constitutional law of exception reveal the deep consequences that crises bring to the core of constitutionalism as mindset, if we want to invoke Koskaniemi and a particular Kantian vision of constitutionalism. That core is separation and interdependency of powers, protection of fundamental rights, and in generally juridicity, the German and also the Portuguese Rechtsmäßigkeit of public action. I will not be able, and also I will not dare, to commentate all the topics chosen by Professor Kaiser, so I will focus in 2 or 3 ideas. Actually, there will be 7, but I don't want to scare you. First of all, and with the purpose of stressing the differences between Portuguese and German systems already pointed out by Professor Kaiser, I will stress that the experience of the Weimar Republic based on Carl Schmitt's doctrine, and especially the experience of the Nazi abuse of Article 48 of the Constitution, the Weimar Constitution, highlights the dangers of a constitutional or legal framework that promotes the empowerment of the president, allowing him to temporarily suspend fundamental rights without a real concurrence of the other constitutional organs. This is why the Portuguese system actively involves the parliament within this process. In fact, the state of emergency supposes an agreement between the 3 main constitutional political institutions, the president, the government, and the parliament, within a system of checks and balances. Second, and whenever the legal systems recognize the essentiality of the opposition between the so-called law of normality and the law of the exception, I will underline the importance of codifying this law of the exception or this kind of constitutional state of necessity. And instead of leaving the problem to interpretive solutions and mainly outside the Constitution, as it is traditional, for instance, in Switzerland. However, the Portuguese constitutional design of the state of emergency does raise serious doubts. For instance, it is conceived for a short period of time, 15 days, but it may from time to time be renewed, subject to the same time limits. The experience demonstrates already that pandemics was here to stay, and currently we are assisting to successive renewals of the state of emergency, which can be counted as a disadvantage of this model of suspension. And this reveals clearly that it is not able, this state of emergency, it is not able to deal with pandemic crisis. My third remark will underline a common topic, the absence of a healthy emergency in the constitutional texts, both in the Constitution of Portugal and in the Code Gazettes. However, differently from Germany, we have a general provision in order to deal with a so-called public disaster. But the question remains, what can or shall be addressed as a public disaster? Fourth, Professor Kaiser told us about the introduction of a new stage of emergency into German law, the epidemic emergency of national concern, and its relevance concerning the Federal Ministry of Health's competence to issue executive rules. Portugal faces an analogous problem, but the framework even the constitutional framework is rather different from the German one. In Portugal, under normal conditions, government has already competence to enact independent executive rules. Those independent regulations may even be issued under Article 199, Section G of the Portuguese Constitution. According to this disposition, the government is competent to perform all activities and make all the arrangements necessary to promote economic and social development and to meet community needs. Nevertheless, this power has limits. One of them concerns precisely the matters related to rights, freedoms, and guarantees. But this topic attests the important role played by the government acting within its administrative powers. So the important role played by the government under normal circumstances, a role traditionally increased in times of exceptionality. There was a moment this year when we found ourselves on a kind of time travel back to constitutional monarchy, and we have a kind of dictatorial decree and a bill of indemnity. But not only the government has the responsibility to execute the decree of the president that declares the state of emergency, but also the insufficiencies revealed by the constitutional state of emergency were tackled by administrative legal instruments, states of all alert and contingence, and the special administrative state of exception of calamity. Provisions that strengthen the centrality of the government. In addition, in the event of public health crisis, the Portuguese law on public health monitoring attributes to the Ministry of Health a competence to enact executive rules as well as any exception measures involving the restriction, suspension, or closure of economic activities, the separation from healthy people, means of transportation or merchandises in order to deal the dissemination of the infection or contamination. And this is what I wanted to share with us with this table. I will try to share, so please 1 moment for technicalities. So we have here the constitutional states of exception allowed by our constitution, and also they are facing the special administrative states of exception, and we can see here the differences between the coexistence of a suspension model and also a restriction model, and all with the exception of the state of siege, all of them were some way or another were used during the pandemics, and they tried to express all the difficulties and all of the problems related to the centrality of government. So back to my remarks. At last, and as Professor Kaiser stressed already, under exceptional circumstances, it is really important that the rule of law really functions. In spite of believing that the rule of law is functioning as it should, also in Portugal, I could not conceal that there are few judicial actions on pandemic measures, as you can conclude from this table. I will try again to share with you. So those are, until now, those are the main decisions of, excuse me. Those are the main decisions and the jurisprudence already enacted in Portugal. And I will make a brief commentary on a synthesis about that. But I wanted, sorry, it's really okay. A preliminary analysis of this data allows some reflections. From a comparative law perspective, and Professor Kaiser told us about the impressive number of over 1,000 published administrative and constitutional court decisions on pandemic measures. So from a comparative law perspective, we do not have a great number of decisions. But this does not mean that Portuguese measures are less problematic or do not raise constitutionally or legality questions, as we can attest by reading the dissenting opinions. On the other hand, the Constitutional Court lacks powers to rule in proceedings especially designed to protect fundamental rights against public authorities, like amparo or Verfassungsbeschwerde. The Constitution remained not indifferent to this problem. Article 20, Section 5, added by the 1997 amendment, established that in order to defend personal rights, liberties and guarantees, the law shall provide citizens with legal procedures that are characterized by swiftness and priority, so that there is effective and timely protection against threats or violations of these rights. In 2002, the requirement has been met by the creation of the Right for the Protection of Rights, Freedoms and Guarantees within the jurisdiction of administrative courts, a mechanism that aims at condemning administrative entities to adopt a conduct which is indispensable to the exercise in good time of a right, freedom and guarantee. Concerning the pandemic measures, this absence has the effect and has the effect of sharing the power to protect fundamental rights between the Constitutional Court and the Supreme Administrative Court, the latter playing an outstanding role on this matter. Third, the decision of the proceedings was fast and therefore fulfilled the swiftness and priority demanded by the Constitution and the substantive exigencies of rule of law. Four, the principles of proportionality and equality were taken as standards of review, revealing also at some degree the difficulties or the weaknesses of the traditional understandings. And, at last, the courts begin to appeal to comparative constitutional law, which expands the horizons of the solutions to concrete problems and enables the enlargement of testing ground of the plausibility of the argumentation underlying the rulings. So those are the main commentaries that Professor Kaiser's outstanding and deep speech required to me. They intend to be a kind of dialogue with Professor Kaiser's speech, and so I'm very thankful for your attention.
Thank you so much, Professor Ana Raquel Muniz, an associate professor, not assistant, as I mistakenly identified. Sorry for that. I really thank you, and I salute the fact that you were able to present in really broad scope, but also very detailed, the current situation and the state of the court decisions, for example, which I think is extremely useful in order to give this debate, I would say, even more substance. And thank you for that. Very interesting comments. Before probably giving Professor Ana Bettina the possibility of replying and starting a debate, I would go on to Professor Miguel Nogueira de Brito, and the reply would be probably for all the comments that have been presented. Professor Miguel Nogueira de Brito is, as I mentioned before, an associate professor, part of the research project in states of exception we have recently begun at the Lisbon Center for Research in Public Law. His PhD is on the right to property in a constitutional democracy. He was very active in a recent time of crisis that strained constitutional rights, which was the financial crisis, namely commenting on the Constitutional Court's decisions regarding, for example, restriction of rights, social rights, for example, and during the time of the financial crisis, which I think is somewhat of a precedent for some of our debates right now. He has been very, very active, a very renowned scholar and respected scholar in topics of constitutional law, constitutional rights, political science, and we are very much looking forward to hearing from Professor Miguel Nogueira de Brito, also commenting on Professor Ana Bettina's lecture. Thank you, Professor.
Unmute myself. Thank you very much, Miguel. I was saying, first of all, I would like to thank very much Professor Ana Bettina Kaiser for her willingness to share with us her thoughts on the state of exception under German constitutional law and the current pandemic crisis. And this for two reasons. First, she has prepared a talk that is specifically addressed to Portuguese, or at least to foreigner constitutional lawyers. Her subject is, what can the German constitutional law on the state of exception teach other constitutional orders, such as our own, on how to deal with the current pandemic? And my answer would be a lot. And a lot, first of all, because for historical reasons that we are all very much aware, it is possible to distinguish German law on the state of exception from emergency laws on almost every other European country. And the second reason is this: I cannot think of anyone better prepared to deal with this issue than Professor Ana Bettina Kaiser. I think we can even say that she is one of the few constitutionalists that was not taken by surprise by the pandemic. As Miguel Assis Raimundo has already said, early this year in January, and just before the pandemic began to take its dramatic toll all across Europe, Professor Kaiser published an excellent book that deals with the state of exception in a systematic and innovative way in the European constitutional context. I think the main purpose of her book, if I'm allowed to summarize it, is the inversion of the classic sentence, necessitas legem non habet, or necessity knows no law. Instead of this, Professor Kaiser proposes to reconstruct the German constitutional law of exception under the opposite motto, necessitas habet legem, necessity as a law, and this is the law of fundamental rights. In my opinion, the current pandemic has proved a right. In these brief commentaries, I would like to stress three main aspects. First, I think it is necessary to explain why what Professor Kaiser called the model of suspension is really today outdated or in a certain way obsolete. Second, I think we have to ask, and this is a reflection on Professor Kaiser's excellent presentation, whether the possible dangers of the model of suspension of rights can also be found in the model of the restriction of rights. And finally, I think that one of the main virtues of Professor Kaiser's proposal is that the model of the restriction of rights is not only the preservation of rights, but also the preservation of the quality of democratic life. So let me explain these 3 points. The first point, I think, to speak of a model of the state of exception based on the suspension of rights means accepting that in emergency times, rights are no longer subject to restrictions, as is the case in normal situations, but are simply suspended, albeit with some limitations. In other words, according to this model, during an emergency, rights apply no more, and public authorities can act without the constraints that usually result from them. Well, the special intensity with which fundamental rights are hit within the suspension model justifies that it can only be enforced for short periods of time. According to Article 19 of the Portuguese Constitution, neither the state of siege nor the state of emergency may last for more than 15 days, notwithstanding the possibility of renewals. However, the situations that justify the states of exception have been submitted to structural changes in the last years. Instead of war, we have global terrorism, considered as a police matter, certainly with international dimensions, and instead of isolated cataclysms, we have extreme natural phenomena that occur more and more frequently. It is therefore doubtful whether the suspension model is the appropriate way to deal with a world in which there is a tendency towards the normalization of exception. And in this new context, the model of suspension cannot be the only way to deal with situations of exception in the modern world. The current coronavirus pandemic is a good example of this. So my second point is whether the dangers of the suspension model are not, after all, replicated in the restriction model. First of all, let me contextualize the Portuguese system of the state of exception. It has already been here said that we have a suspension model in Article 19 of our Constitution, but because this model was thought for short periods of time, our model is in reality a dualistic model. We have a suspension of rights during states of emergency, and then we have some models of administrative restrictions of rights outside these short periods of states of emergency. Well, this dualist structure is not without dangers. There is, in fact, a tendency to conceive of the longer cases in the same way as the shorter ones. In other words, there is a real danger that the suspension model will expand and start to be used to deal with all states of exception. And perhaps the Portuguese case can be used as a good example of this danger. Since the beginning of the crisis back in March this year, we had a cycle in which the state of emergency, conceived according to the suspension model, has alternated with the less hard situations of contingency, alert, and calamity foreseen in the law of civil protection, and we should comply with the more demanding requirements of the restriction model. But in practice, we can see that there is a tendency to that these two kinds of situations become undistinguishable in practice. And we have to ask, is there not the same danger in the restriction model in Germany? In her presentation, Professor Kaiser alludes to this danger when she mentions Section 5 of the Infection Protection Act, according to which once an epidemic emergency of national concern is declared, its paragraph 2 gives to the federal Minister of Health the power to issue regulations that may deviate from a number of federal statutes. Furthermore, and more importantly, Professor Kaiser alludes to what I will call the leveling effect of the principle of proportionality, and which tends to be ineffective in times of crisis. So, is not this situation a kind of Trojan horse, or in other ways, we have to ask whether these provisions of Section 5 of the Infection Protection Act and this jurisprudence of proportionality are not opening the floodgates of exception, as she has mentioned. The real question, I think, is this: is it more dangerous to have some elements of the model of suspension in a system that conforms in general with the demands of the model of restriction, or to have a coexistence of the two models, as is the case in Portugal? To put the things in perspective, let me compare briefly the output of these two models in Portugal and in Germany. In Germany, the most important instrument to fight the coronavirus pandemic is the Protection Against Infections Act from 2000, and amended in March, May, and November this year. In Portugal, if we want to understand the multiple instruments that have been adopted to the same effect, we have to distinguish three levels. First of all, the level of the declaration of the state of emergency issued by the President of the Republic, of the Portuguese Republic. To this moment, we have had already 6 such declarations and the corresponding government decrees that develop such declarations and adopt the corresponding measures. At the second level, we have a legislative act that was approved by the government and then confirmed by Parliament in conditions that are not constitutional correct, at least to my view. And such legislative act has been amended 11 times, to this day. And finally, in the third level, we have the multiple declarations of situations of calamity issued by the government based on the Civil Protection Act. So we have a chaotic situation in what respects the instruments to fight the pandemic, and this is, I think, a necessary feature of, or at least a natural consequence of the suspension model that was adopted in our constitution. So my final point about the preservation of democratic life, that I think is better secured in a model of restrictions of emergencies. And let me give an example. There was a recent decision by our Supreme Administrative Court, and this court ruled that the measure approved by the government to ban gatherings of more than 10 people is not, under the circumstances, unconstitutional. This is, of course, problematic. As Professor Kaiser's presentations makes very clear, there is certainly reason to agree with the German Federal Constitutional Court when it refuses a blanket ban on all assemblies, a blanket ban on the right to meet. But on the other side, we have to ask, is it not possible to read in the measure of the Portuguese government the willingness to respect at least the essence or the core of the freedom to assemble as foreseen in Article 45 of our Constitution? And in fact, in a way similar to Article 19 of the German Basic Law, Article 18 of the Portuguese Constitution states that restrictive laws cannot reduce the extent or the scope of the essential contents of constitutional rights. So I think this question is relevant to Professor Kaiser's main thesis in her book on the constitutional law of exception. The principle of the protection of a balance-free essence of constitutional rights could compensate the inability of proportionality to protect rights in times of crisis. But this principle must be enforced first and foremost by the legislative body, and this takes me to the final point. The above-mentioned decision of our Supreme Administrative Court ruled that would be enough for the above-mentioned measure to be approved by a mere government regulation without a solid parliamentary basis. Furthermore, and as an alternative to this parliamentary basis, the court considered that these rules could find their legitimation basis on the norms of transnational administrative law, including the recommendations of the World Health Organization. Now, for me, at least, one of the main virtues of the restriction model advocated by Professor Kaiser is precisely to enforce the exclusive legislative competence of Parliament for both normal times and situations of extreme crisis. So I would say that the thrust of this model is not only the preservation of rights, but also the preservation of democratic lives. And so these would be my comments. Thank you very much once again, Professor Kaiser, for your excellent presentation and very instructive one.
Thank you so much to Professor Miguel Nogueira de Brito for very sharp comments and also informative, I believe, and very useful also for the upcoming debate. I would suggest our keynote speaker and our commentators for the following minutes to proceed as follows. I would probably pass on the floor to Professor Ana Bettina, who listened to the comments and would probably have something to say. And then afterwards, maybe we could start on a more open style debate. So maybe the commentators would also be, could also turn on their microphones and possibly start a dialogue if they see fit, if and when they see fit. That would be my suggestion for the following moments. Just before I give the floor to Professor Ana Bettina, I would just like to, it was a extremely rich, I think, presentation. Just to point out, in addition to the comments presented by my colleagues, 1 or 2 points about, could you please elaborate more? I think it would be very useful for us on the weakness of the proportionality principle. And for example, the point you mentioned about uncertainty, could it be the case that, for example, the fact that uncertainty was very strong at the beginning, but now it isn't that exactly a show of the importance of the proportionality principle? As we know, when there are uncertainty of empirical assumptions, the proportionality principle varies. But maybe today, is it so easy to say that today, when we know a lot more, for example, about the virus, is it such a weak instrument? And furthermore, how would you see the difference between the proportionality principle and the core essence of a fundamental right in terms of a control mechanism? What would be the major differences? And I would just go to the point which I think you mentioned, which is very interesting regarding freedom of assembly. Because you mentioned the idea of a de facto harm of the essential core of the right, because de facto the manifestation or the demonstrations were stopped by the authorities or by the rules that they enacted. Could it be the case that you mentioned that this would be considered harm to the essential core of the right? But in a restriction model, really, could there be no situation in which you have a very clear situation that, for example, for 2 or 3 weeks, people cannot assemble? Would that be harmful to the essential core of the fundamental right? Do we have to conclude that it's impossible, even in the most pandemic high point of the pandemic, to stop people from gathering in meetings? Would that disrupt the essential core of the fundamental right? Also, just to give, this is probably a bit provocative, but people in Portugal have been arguing about the lack, the insufficiency of the normative grounds for the decisions that have been taken, mostly due by regulation forms by the government. Actually, one of the dissenting votes, as Professor Ana Muniz referred, in one of the decisions of the Supreme Court, the Supreme Administrative Court in Portugal, one of the dissenting votes, so 2 votes in favor, 1 dissenting vote, one of the dissenting vote said actually that there is insufficient grounds for the measures that have been taken. But Professor Ana Bettina complained that it was too late, that the German parliament acted in November. Well, thus far, the Portuguese parliament has, in the midst of all the situations that have occurred, approved a law regarding the use of face masks. All other situations, which are very intense restrictions to fundamental rights, have not merited from the parliament, I think, in many cases, the attention that they should have, namely in terms of the laws that form the basis of the decisions that have been adopted by the government. So maybe we have something to relate to or not regarding the German situation and the action of the parliament. So Professor Ana Bettina, please, how would you reply to the comments you heard? Any points you would like to point out? Please, the floor is yours.
Yeah, first of all, I want to thank you for so rich and thoughtful comments. And of course, I'm a bit overwhelmed. And also, I have taken 3 pages of notes, so I somehow don't know where to start. Maybe I start first with the thought that the 4 of us seem to have agreed on several points. First, that the model of suspension, that the suspension model is highly problematic, and that is probably because it was a model invented in the 19th century, and we can now see that it's really a model that doesn't fit to our days. And the reason for that were pointed out in the second comment, mainly that when the model was invented, people thought of war or internal uproar, but of course not of modern phenomena like terrorism, natural disasters, pandemics. So not only the model of suspension seems to be outdated, but also time limits of 15 days and so on and so forth. Second, a second point that was always raised was the problem of the role of Parliament, whether it should have done more, and whether now the pandemic has become the hour of the executive. Don't know whether that's a German saying, but we always ask ourselves: is the crisis the hour of the executive? And in Germany, in some ways, not in every aspect, in some ways it has become the hour of the executive, because first and foremost because the COVID regulations were executive regulations. Although one has to say that that it's the parliament that has to decide whether we have such a pandemic of national importance or not. Yeah, let me maybe start now with the question of proportionality. I agree as far as the knowledge question is concerned, I agree. It was especially a problem at the very beginning of the pandemic, when we more or less didn't know a thing. We didn't know whether it was the air that helped to transmit the disease, or whether it was a problem also of touching things. We just didn't know. And you're right, we have acquired more and more knowledge. And so your question was, is the principle still a weak principle? And I would say, yes, you're right. It's probably less weak than it was before, but we still see the more or less the same problem. Let me give you an example. In October, when the German government, or the governments of the Länder, realized that the pandemic might come back after a calm summer, they started with the so-called, as we call it, lockdown light. So the strict lockdown has started yesterday here in Germany, but before, in October, we started with the lockdown light. And the lockdown light started with the following measure. It was forbidden for hotels to accept tourists. So you could stay in hotels for business reasons, but not for touristic reasons. And the hotels challenged these measures. And in some Länder, they were the higher administrative courts gave or squashed the measures by the government and said, yes, the plaintiffs are right. Those bans are disproportionate. So now, on one hand, you could say, oh, this shows first that the principle of proportionality has gained importance. And second, this also shows that the courts maybe lost their timidity and became more self-confident. Yeah. So that's the one side. But the second side is that one could ask the courts, well, how do you know that those bans to accept tourists in hotels, that this does not help to fight the pandemic? How do the courts know? But they think it's disproportionate, so how come? But because the problem is that probably fighting the pandemic means that the state has to take various sorts of measures, and nobody knows in the end, if the numbers have gone down, hopefully, which element or which measure exactly was successful.
Yes, so Professor, that's why you say, and I think it's an important point to point out, that you say that equality, on the other hand, has had, I think it was a very stark point you made, and a really important one. And I would say that for example, the case law in Portugal and other countries has demonstrated this. It's a lot easier to say that the measure is unequal than to say it's disproportionate. And on the topic of the essential core of the fundamental right, would you care to elaborate more?
So the current or the mainstream doctrine is that essence principle that you also know in the Portuguese constitution, as I understood. So the mainstream doctrine in Germany is that it's more or less the same thing as the proportionality principle. And this is why the courts don't rely on the essence principle, because, you know, it has lost its sense. And my proposal is that this principle is correctly understood only if one says that there is a core that can't be weighed away. That there can't be a weighing of principles. And so your question was, would that really mean that even for 2 or 3 weeks, it would be against that principle to forbid assemblies? And my answer would be yes. Also, I mean, what I could think of is, one could say, okay, if there is an assembly, maybe we have a restriction of numbers of people. Of course, I would also say it's a problem if 40,000 people want to arrive, right? Like in Berlin, what we had in the summer. But we can say we have a limit of people. We can say those people have to wear masks, they have to keep the distances, and so on and so forth. But if all of those conditions are really met, I think the right of assembly should always, even in the worst pandemic, be possible. And even if one says only assemblies against the COVID measures are allowed, maybe one could, for 2 or 3 weeks, forbid other topics of assemblies, but at least, I think, at least it must be possible for people to show outside that they are against the state of emergency. I think that's the absolute minimum that has to be possible. That would be my proposal. And yeah, as to the lacking legal basis, I mean, I think most of the states, as far as I know, follow the Portuguese model. So most of the states don't have a problem to also to allow.
So there seems to be an interruption.
Yeah. So.
Oh, okay. Now we're hearing you.
Yeah.
Please continue.
Okay. My last point was about the parliamentary basis. So I think most countries are less strict than Germany, accepting more executive rulemaking than Germany does. And so it seems to me also a cultural thing. Of course, we were all too it was all too easy to have executive rulemaking in the Weimar Republic. And due to this experience, we are extremely reluctant to accept executive rulemaking that has no legal basis in parliamentary acts. But maybe some critics argue here in Germany that maybe we exaggerate our doctrine now in the other direction, you know, and that seems to be the case with my colleagues that, you know, that saw in section 5, paragraph 2, they already think, oh, that reminds us of 48 Weimar Republic, Weimar Constitution. And so, you know, we might have a problem in the other direction, that we exaggerate now our new way, you know?
Yes, the need for density. Yes, please continue.
That I haven't mentioned so far. When Parliament reacted in November and they introduced in the new section 28A of the Infections Act the possibility that now the executive is explicitly empowered to close down business, to restrict assemblies, and so on and so forth. Now parts of the population were shocked, because they say, oh, now Parliament is taking away our rights. Because, of course, they didn't understand that this was a progress. You know, like from a legal point of view, it was a big progress that finally Parliament accepted that it had to act and that it couldn't leave the place to the executive. But the population, of course, doesn't know about the legal doctrine, and they ask, oh, so now after those great restrictions, Parliament comes and takes away our rights. And that's
the thing with democracy, right? Democracy makes everything visible. So it was only when you discussed it in Parliament that people realized what was happening. So I can really understand that. So,
yeah,
sorry,
they realized it before, but now they said, okay, now it's kind of official. Now they are officially taking away our rights. So, and maybe that shows also the ambivalence of Parliament acting, because now it's in the law, and after some time, after something is in law, there's always also the danger that it somehow stays, right? Let's think of the French état d'urgence. when Macron came, he said, oh yes, the état d'urgence has to be ended. But how did he end the état d'urgence? He transferred the état d'urgence in normal law. And then afterwards he ended the état d'urgence, yeah, because everything was in normal law. And so that's also always in danger.
Yes, absolutely. Yeah. I don't know if Professors Raquel or Miguel wish to make any further comments, or since I'm seeing, yes, I was exactly going to open the floor. Since I am seeing such qualified attendance here, it would be a shame not to open the debate. So Professor Blanco Moraes wishes to take the floor. Please, Professor.
Thank you very much, Professor. I would like to present my compliments to Professor Kaiser for your outstanding intervention. This sort of meeting is linked to a research project about the administrative and constitutional exceptional measures that are oriented by Professors Miguel Raimundo and Nogueira de Brito. So I think we have a very interesting and productive moment by the intervention of Professor Kaiser. About the questions that were spoken and aroused by the intervention, I must say the following. About the right of assembly, we are in almost electoral period for the election, the direct election of the President of Republic. And the problem is that although political rights are not really suspended, anyway, we will have an electoral campaign that will be essentially reduced to the internet and to public TV and radio debates. And I think the public assemblies would be, by the climate created, will be necessarily restricted. So how can we live in democracy, and especially in electoral periods, in such states of exception like the emergency that was declared by the same President of the Republic? It's a question that concerns me. If the pandemics will last, every sort of elections will have a path to some sort of virtual world. I think that will affect our public and individual liberties in the political field. I'm not too much critic about a dualist model. About suspension of rights, I think our constitution is not so bad about the way to suspend fundamental rights by a cause of pandemics, because state of emergency is also justified about calamity, and it was about a public calamity that it was declared by the President of the Republic. I think it has some sort of advantages because it's temporary. It lasts just during 15 days, must be renewed, has been renewed by control of the Parliament. We have parliamentary control in the renewal of state emergency, which is important. It's different to have a law that lasts and gives administration clout to take on restrictive measures on fundamental rights. Here we have more or less the name of the game in the decree of the President of the Republic that discriminates the fundamental rights that are suspended. And the suspension is partial, as we know. In state of emergency, we cannot suspend all sorts of rights. Our main problem is the mechanism, the implementation of state emergency, because the President of the Republic didn't make some sort of concretion of the ways that those rights should be restricted or suspended. He made some sort of general standards on the subject and let the government making primary regulations, rules, primary administrative rules and governmental laws, that sort of restriction. So the president washed a little bit his hands on the concretion of the suspension measures and let the government do the work. And they did more or less well, but it's a new sort of practice in sort of suspending rights. About the laws, I'm not against the implementation of laws when we don't have the state of emergency. We have some sort of laws linked to health measures, and we had the state of calamity. That is not a formal state of exception. It was created by law. The main problem is that those sort of laws, they don't identify exactly the fundamental rights that can be restricted by administration. And my doubts about the legislative way or legislative path in such terms is that we have the statute of calamity declared by the government by a law habilitation, but the administration is too free, it has too much freedom to restrict fundamental rights that are not exactly identified in the laws. And my fear on that is that the law, it's not necessarily a temporary law. It's applied when it is necessary. And as was put on, the Supreme Administrative Court was too much friendly with the administrative governmental measures to restrict fundamental rights. And it was really too poor in the justification. Some of the votes of the members of the court were appalling for me in juridical terms. So we must have the two models, the dualist model, and I think we must improve both. We must hope that the President of the Republic would be a little bit more careful in make the concretion of the restrictions and to limit a little bit the intervention of the government on that field in order to assume the responsibilities that we have for the president on that field. And I hope that the laws about public calamity and others, or state of alarm and calamity, should be amended in order to identify with clarity the fundamental liberties that should be restricted by administrative measures, because we don't want, it's not the case in Portugal, to have some sort of authoritarian administrative state created in the grounds of the pandemics for the future, and even when the pandemics will end. Thank you very much.
Thank you, Professor Blanco Moraes. It's such a privilege to have your a short lecture from Professor. I had a request, I have to tell you, from Pedro Delgado Alves, who is also a lecturer here at the law school. And in addition to that, and probably with further relevance, he's a member of parliament. So it would be an absolute shame not to give him the floor for his comments. Please, Pedro.
Thank you very much, Miguel, and thank you for the opportunity. Again, I also transmit my thanks for the presentation and for the comments. They're very they're essential for, I think, for everyone, both in academia and for decision makers. And in fact, I was listening to the comparison. It's interesting that the issues are very much the same, although the framework, the constitutional framework, is quite different. And the concerns and the way we approach each other is interesting, because what we fear in our answers is precisely the same fear that you have with the different framework that we, or at least some of us, would envision and ambition to have. And in fact, I think that one of the great problems we have is that there are several degrees of legislation and constitutional frameworks being brought into the field of discussion, but there is no actual good coordination between them. As Professor Blanco Moraes was pointing out right now, the fact that we have a framework law on civil protection that allows for the government to use it for states of calamity, contingency, and alert, and therefore restrict some fundamental rights. Although we have it, it was designed and thought of for natural disasters that have local, regional basis, and not for a long-standing state of emergency, which is what we in fact have due to a pandemic. And unfortunately, I think the problem we face is we do not have an adequate credential on a constitutional level to allow for framework legislation on civil protection to be the habilitating framework for additional restrictions. And when we discuss, and we've been having this discussion here in Parliament and elsewhere, on the possibility of having a specific legislation to deal with pandemics, the concern is obviously that we could be circumventing the constitutional provisions on the state of emergency by creating a permanent state of emergency through an act of Parliament, which is far worse than having to renew it every 15 days. Obviously, I think we can discuss whether 15 days is adequate for this type of emergency, but naturally that's a discussion we'll have to have some years, but not some years from now, but some months from now after the pandemic. We cannot have it right now. And everything considered, I think it's better to have a model where you're forced to go to Parliament every 15 days and renew the credential for the new measures and for the new restrictions than to have a degree of permanent instruments in force. However, and this is the interesting part as well, I think, simultaneously, we have the exceptional measures passed through the authorizing resolution of Parliament that allows the President to decree the state of emergency and then allows the government to regulate it. And it's here, I think, that we have the largest danger for the system. The fact that, in fact, we have a suspension model, which means we suspend we suspend fundamental rights, but because we do so, this allows the government to regulate administratively through the decree that regulates the execution of the state of emergency to actually pass laws, not laws, but pass norms, regulations on the restriction of fundamental rights. And in fact, it has been the government that has been deciding over the past few months, when we have the state of emergency, what exactly the scope of the suspension is going to be. So in practice, we're using the suspension to habilitate the government to do a restriction. In fact, we've hidden a restriction model inside a suspension model, where what Parliament does is we suspend the fundamental rights. The President of the Republic requires Parliament to authorize the suspension of the rights, but then the government in detail is the one that actually operates and puts the restrictions in place. And here, I think, is where we have the greatest challenge to the separation of powers and to the competences of Parliament and of the government, because it's here that Parliament does not have, in fact, the last word in what exactly gets suspended, and that we actually have a growth of the size of the executive. Additionally, just this other comment, and it was mentioned, I think it was Professor Raimundo that mentioned it, Parliament only passed one relevant law in terms of restrictions, the one relating to the masks. Here I would beg to differ slightly, because in fact, we've been producing, both government and Parliament, additional legislation relevant to deal with the pandemic, but outside the scope of the emergency measures. That is, we both actively legislating, Parliament and government, and maintaining regular legislative activity in areas that are sometimes covered by the decree of the state of emergency and sometimes not covered by the decree of the state of emergency. It's a bit à la carte. And so we've had legislation on the masks, for example, but for example, Parliament was summoned also to pass legislation on the functioning of local authorities, for example, allowing them to meet through video conference, which is something it had to be habilitated through an act of Parliament. We suspended and then amended acts on criminal and civil procedure and made changes to suspension of deadlines and other measures that could have been implemented inside the decree of the state of emergency, but were left to a regular law of Parliament. We've had changes to tax law. We have changes to relations between tenants and law and their landlords.
But not fundamental freedoms. right?
Not fundamental freedoms, but well, in some cases,
the rule that provides that you can only gather more than 5 or 10 or whatever people is in a resolution by a decision by the government. So
but criminal procedure
that was the point. That was the point. Of course, there
example,
are many laws.
But I think in some cases it's still fundamental rights, and still we're still within the scope of rights, freedoms, and guarantees. Namely, for example, criminal procedure guarantees that were part of the original package passed in March, Law 1A 220, which in fact had a lot of measures not dealing necessarily only with the framework. And finally, just one final comment. I would just
just to wrap up, because I have another request, and I would like to conclude.
Yes,
give the floor to our commentators.
Yes, very briefly, just on the issue of equality and proportionality. I think also equality also gets reinforced and boosted as a test mechanism with access to further knowledge. I think it doesn't apply strictly to proportionality. Obviously, there the scope is very clear, but the feedback that we've been receiving in Parliament, in fact, most of the complaints deal mostly with groups that feel discriminated against in the implementation and design of the laws. And it has increased, interestingly, throughout the months as people become aware of the characteristics of the virus and how that affects them or does not affect them, and therefore should justify or not justify additional measures. Thank you very much, and sorry for...
Thank you so much, Pedro. Before I give the floor, maybe I would give the floor to the commentators and then to wrap up our keynote speaker, Professor Ana Bettina. But before that, we have just 2 quick questions. Yes, that's the case, from Dr. Joaquim Pedro Cardoso da Costa. Please. Also,
thank you very much. Very quickly, I would like to add two points. One regarding what Professor Blanco Moraes and also Pedro stressed out is about the relationship between the decree, the deliberation of the president stating the state of emergency and the concretization by the government to one point of and I would like to have the comment of the 2 Portuguese commentators. To one point of the state of emergency law. At that point, that law was passed in 1986. It is the first time that it was applied. And one point of that law states that the president proposes or asks the permission of the parliament to impose a state of emergency, but the parliament has only two choices: or it doesn't approve or it does not approve, but it cannot amend the requisition of the president. My point is this: we have a semi-presidential system, whatever we wanted to call it, but the practice that we have in these months is the president authorizes the government to enact the suspension of the specific rights, but the specific measures, as for instance, now it's Thursday, the parliament has just made this 3rd or 4th renewal, and only Saturday we are going to know if we are allowed or not to be with our families in Christmas, because the concrete measures will be those that are decided by the government. But in that way, I think that the authorization of the parliament is somehow diminished, because in practice, it's a double authorization from the parliament and the president to the government. But my question is, shouldn't we allow the parliament to enact, for instance, to
change the presidential,
somehow specify the proposal of the government? That is the first point. The second point, very quickly, is about the model of the courts and of the control systems in the case of emergency. My point is this: at least in Portugal, I think we should think of a model where in emergency, in suspension law, or even in the laws of restriction for calamities or so forth, we should have specific measures regarding specific procedural measures for the courts. We should stress out something like emergency procedures in courts. Okay. Every time there would be a state of emergency, applied. So specific provisions and not the general provisions of administrative and constitutional court procedures. That is my proposal.
Thanks. It became clear the problem of judicial protection, mentioned by Professor Anamri, for example. So maybe my suggestion is the following: reverse the order from the comments. So beginning with Professor Miguel, then going on to Professor Anamri, and finally finishing off with Professor Ana Bettina, if you agree. Miguel, if you'd like to wrap up.
So I think these comments were very useful and very thoughtful, but I think in a way my feeling relating to our experience is, in a few words, is this: besides a pandemic situation, we are living a pandemonium legislation, if you want. Forgive me the play with the words, but this is our main problem here in Portugal. We have not a clear legislative framework or administrative framework to deal with this situation. So it's very difficult to explain to someone what are the measures in place at this moment, or in reality at any point since the beginning of this situation. So for me, this is the main problem, and I think the suspension, this is a problem that is endemic to the suspension model. Well, I might be wrong, but this is really my feeling. And I think the German experience has something different to taught to us that has not been mentioned, and this is if you read the German Protection Against Infections Act, they have an interesting way of foreseeing the measures that restrict fundamental rights. First, they point the measures, and then they say what are the fundamental rights that are affected by such measures. And this is, I think, really important. In any way we choose to deal with this problem, we have to have a clear sight, a clear vision of what exact fundamental rights we are affecting or restricting with our measures, be they measures in a state of emergency or in a situation of calamity. So my main point is this: we have to change our way to deal with this situation. We have to have better legislation, and first of all, and the most important, we have to have a clear view of what kind of rights are we affecting with which measures. So this would be my last point. Thank you.
Great final comment. Professor Ana Bettina, please, would you like to make some remarks?
Thank you very much. This is really an interesting debate, and I will only stress two topics. A main one, this is a concurring opinion with Professor Nogueira de Brito, and I will stress that the absence of a systematic and I stress and I underline systematic framework to deal with the pandemic situation. It demonstrates that normality or exceptional situations show us that we are again back to the core or the foundations of constitutionalism. Again, we are within the problems of protection of fundamental rights and separation of powers, such as in 1789 showed us. And this problem is clearly attested by the problem of legal basis to enact executive rules I agree with Professor Nogueira de Brito when he says that the important point here is the exclusive legislative competence for the restriction of fundamental rights. In fact, the importance of this competence cannot obliterate that comparative law is important, as was pointed out by the Supreme Court, Supreme Administrative Court, but it is not a replacement for a legal basis. Comparative law is performative and is argumentative, but it must not replace the liaison between the rule of law in the sense of Rechtsstaat and democratic principle, which is the punctum crucis of the legal basis. And I am generally considered very generous as far as governments and administrative competence to enact administration's competence to enact regulation, but even I think that we will need an actual and precise basis. On the other hand, and when I think of the remarks of Professor Blanco de Moraes related to the laws that are being identified by as legal basis to enact regulations, in fact, as my table showed, they do not identify precisely those rights. We have just some, we can identify some of rights, but the basis, the legal basis, allow a restriction of several other rights. So it were those three points that I would remark, and I thank you again for the invitation and the opportunity of learning with Professor Kaiser, namely. Thank you.
Thank you, Ana Raquel. Great final remarks. So, Professor Ana Bettina, your lecture spurred this kind of comment, the high-level comment and debate, and I think this is the best comment that could be made of your lecture. Thank you so much again. I would like to give you the floor for final remarks before we close, please.
Well, let me thank you so much again. It's a great honor. I want also to make 3 short points. First, I think we agree that parliaments should take a more active role, and it's not entirely clear why they remain so reluctant and so passive. And I mean, the German example showed that after the pressure of the courts and maybe also legal academia, the parliament finally introduced that section 28A that specifically set out what fundamental rights can be restricted, and so maybe the same happens in Portugal. Second, on a more happy note, I want to say there is one big difference between the pandemic and terrorism, and that is that we have found a vaccine against the pandemic. So even if we don't know when it'll stop exactly, there is hope. And so this state of emergency will come to an end. And a very last short point, and that's a new point that we haven't discussed so far, that is there is an approach that probably also exists in Portugal, and that is the thought of Schutzpflicht, the protection duty, also that the state has a protection stemming from fundamental rights to protect those rights. And we shouldn't forget that the state acts in order to protect the lives of the citizens, and that this is also a question of fundamental rights. And therefore, if we can't see, like we do see in Hungary, that the state uses the situation to become even more even more authoritarian, we should also if this is not the case, like in Hungary, we should also be grateful that we live in states that take care of the most vulnerable groups. That's maybe another aspect that we should think of. Thank you so much, and thank you for the honor to talk with me and to discuss. It was wonderful.
Thank you so much, Professor. The honor was ours. We are wrapping up. It was a very, I think, productive 2 hours. Not a final discussion, I'm sure. So please look out for further initiatives that we will need to make to continue thinking about this. So thank you very much to you all, to our commentators, to Professor Ana Bettina, to all the participants for being here today, and I'll see you next time. Bye-bye.
Bye.
Correu tudo bem?
Sim, foi tudo bem, Rui, obrigada.
Pronto, eu mantive-me aqui porque, pronto, também não... Tá. Mantive o som ligado.
Obrigada. Mas foi tudo bem, não houve nenhum problema.
Sim. Pronto, tá. Pronto, ótimo. Podemos
As pessoas já estão a sair.
É isso, podemos fechar.
Vamos só deixar que elas saiam e daqui a pouco fechamos a meeting, só para não ser abrupto.
Está bem. Pronto, eu espero que saia toda a gente e depois fecham nessa altura.
Há o perigo de haver pessoas que não estão a tomar atenção e, portanto...
Não, às vezes acontece, nas sessões, nas aulas, acontece haver pessoas que saem e vão jantar ou vão fazer outra coisa e deixam a sala ligada. Por isso, acabamos por fechar. Também, se dermos mais um bocadinho, vamos fazer só uma coisa. Colocamos já a tela. Colocamos a tela. Ora... E assim... Ora.
Eu vou retirar as pessoas manualmente.
Ou isso, mas eu também posso colocar já aqui aliás, já está a tela, não, ainda não. Ora, a partilhar, eu partilho aqui a tela do... Ok. O que aconteceu aqui, ó?
Pronto, já só estamos nós.
Pronto,
depois quando estiver pronto avisa-me para nós, quer dizer, para depois eu poder fazer a divulgação de que está